Welcome to our deep dive on what happens when a tourist visit leads to marriage in the United States. In this video, we will map the decision matrix between adjustment of status, known as AOS, and consular processing, known as County Route 1, highlight the risks of preconceived intent, and explain how the 90-day rule affects cases. We will also cover visiting during a pending County Route 1 and what evidence helps demonstrate legitimate post-entry decisions. Let's begin by setting expectations with an important disclaimer. First, a quick but critical note. This video provides general educational information and does not create an attorney-client relationship. Immigration cases turn on specific facts, and your situation may differ in important ways. Always consult a qualified immigration attorney before making decisions that could affect your status or ability to re-enter the United States. With that foundation, let's move to today's roadmap. Next, here is our agenda. We will define key terms, explain intent at entry, walk through a decision flow between AOS and County Route 1, unpack the 90-day rule, list evidence that can help overcome a presumption of preconceived intent, discuss visiting the United States while a County Route 1 is pending, ask 2 short quiz questions, and finish with key takeaways. Now, let's establish the core vocabulary. To clarify terminology, we define several key terms. B2 or ESTA refers to temporary visitor entry for tourism. AOS is adjustment of status, filed inside the United States to obtain permanent residence without leaving. County Route 1 is consular processing of a spousal immigrant visa while the foreign national remains abroad. Preconceived intent refers to possessing immigrant intent before entering on a temporary visitor visa. The 90-day rule is an internal policy framework where actions within 90 days that conflict with non-immigrant intent may trigger a presumption of misrepresentation. The overarching point is that visitors must intend to return home at the time of entry, and early marriage or AOS filings can conflict with that required intent. With terms in place, let's widen the lens to the big picture. Moving forward, the big picture is straightforward. A tourist must intend to return home at entry. If a relationship evolves and marriage happens later, the timing, documents, and credible proof of post-entry decision-making become crucial. We will now connect that principle to the AOS versus County Route 1 decision flow. Next, let's focus on intent at entry. Border officers assess purpose, home ties, and return plans. Not having a return ticket is a significant red flag that can result in immediate denial of entry. Similarly, unusually long, open-ended stays can suggest immigrant intent. Consistency between statements and documents is essential. With that in mind, let's visualize the AOS versus County Route 1 decision flow. Here is a flow of common decision points. If intent at entry was clearly non-immigrant, and the marriage or filing occurred after sufficient time with credible post-entry documentation, AOS may be considered, ideally with counsel. If timing is short or evidence is thin, the risk of a fraud presumption is high, and consular processing is safer. Even if a County Route 1 is filed, visiting during processing requires strong home ties, and admission remains discretionary. To quantify the trade-offs, let's compare AOS and County Route 1 directly. In this comparison, AOS offers potential convenience but carries significant risk if the original entry intent is questioned, especially when marriage or filing occurs quickly. Evidence must support that decisions were made after entry. County Route 1 is slower but aligns with immigrant intent processed outside the United States and generally avoids the misrepresentation issue. However, visits to the United States during a pending County Route 1 become challenging because the foreign spouse has documented immigrant intent and must prove compelling ties to return home. Now, let's explore the 90-day rule and its implications. Now, regarding the 90-day rule. If a visitor marries or files for adjustment of status within 90 days of entry, there is a strong presumption of misrepresentation. After 90 days, the presumption weakens, but officers still assess the totality of circumstances, including unusual length of stay, return plans, and supporting documents. This is a presumption, not an automatic denial, but rebuttal requires strong, dated evidence of post-entry decision-making. Speaking of evidence, here is how to build a credible record. To build a strong record that decisions were made after entry, start by mapping a detailed timeline from entry to engagement to marriage to filings, with dates. Maintain proof of a return ticket and any legitimate reasons it changed. execute joint commitments like a lease or utilities after arrival, and preserve the dates. If relevant, therapy or counseling records may document a recent decision. Include evidence of post-entry life changes, such as a new job or school enrollment. Marries. Preserve communications that show planning occurred after entry. Demonstrate financial independence, which supports the ability to depart and avoid an open-ended stay. Finally, have an attorney review the full narrative and highlight any gaps before filing. Next, let's organize evidence into do and don't categories. Here is a practical checklist. A return ticket at entry supports non-immigrant intent. Missing it raises a red flag. A joint lease signed after arrival supports post-entry decision-making. Therapy or counseling notes may corroborate a recent decision. Job or school changes after arrival help establish that plans evolved later. Dated messages and emails provide organic evidence of the timeline. For visits during a pending County Route 1, short, well-documented trips with proof of strong home ties improve the chances of admission. Now, let's see how a visit is evaluated during a pending County Route 1. When a County Route 1 is pending, the government systems reflect that immigrant intent. At the port of entry, admission as a visitor is discretionary and becomes harder. Travelers should carry strong evidence of home ties, such as an employer letter confirming the job and approved leave, property documents, a return ticket, and proof of family obligations. Visits should be short, with a clear itinerary and credible funding. Next, let's test your understanding with a quick quiz. Quiz time. Question: if a visitor marries a U.S. citizen and files for adjustment of status within 90 days of entry, what is the main risk? Options are: 1. No risk if the couple truly loves each other. 2. A strong presumption of misrepresentation based on the 90-day rule. 3. Automatic approval because marriage to a U.S. citizen is allowed. Or 4. The case converts automatically to County Route 1. You may pause the video now to think about the answer. We will discuss the answer in the next section of the video. The correct answer is a strong presumption of misrepresentation based on the 90-day rule. Actions within 90 days that contradict non-immigrant intent trigger a presumption of fraud that must be rebutted with strong, dated evidence and a credible narrative. Second quiz question: while a County Route 1 is pending, can the foreign spouse visit the United States on a visitor visa or ESTA? The options are: 1. Yes, always with guaranteed admission. 2. No, it is categorically forbidden. 3. Technically yes, but admission is discretionary and requires strong proof of home ties. Or 4. Only if they already quit their job and sold their property. You may pause the video now to think about the answer. We will discuss the answer in the next section of the video. The correct answer is that it is technically possible to visit, but admission is discretionary and requires strong proof of ties to the home country. Because the pending County Route 1 establishes immigrant intent, officers scrutinize such entries closely, and many are refused when ties are insufficient. This mind map places the scenario of tourist to spouse at the center and branches into 3 areas. The AOS branch covers timing, highlighting that actions within 90 days are high risk, evidence types that should be dated and post-entry, and the core risks of preconceived intent and potential misrepresentation. The County Route 1 branch highlights that processing occurs abroad, the timeline is longer, fraud risk related to entry intent is lower, and that visits during processing require strong home ties and short, well-documented stays. The preparation branch emphasizes bringing a return ticket, documenting a precise timeline, and consulting an attorney. This diagram reinforces the strategy. Prioritize lawful intent, credible timing, and strong documentation. To summarize key points: first, visitor entries require genuine intent to return home. Second, AOS filed shortly after entry risks a presumption of misrepresentation. Third, CR-1 is slower but safer when intent is in doubt. Fourth, if AOS is pursued, compile a meticulous, dated, post-entry evidence record. Fifth, visits during a pending County Route 1 are possible but difficult and require strong proof of ties. Finally, consult a qualified immigration attorney to evaluate your specific facts. In closing, intent at entry drives the analysis. Use the decision flow to evaluate whether AOS or County Route 1 fits your facts. Respect the 90-day presumption and only proceed with strong, dated, post-entry evidence. If a County Route 1 is pending, keep visits short and well-documented with compelling home ties. When uncertain, obtain legal counsel to reduce risk. Before we go, thank you for watching. If you found this useful, please like the video, share it with someone navigating these choices, and subscribe for more clear explanations. In the comments, tell us your biggest question about AOS versus County Route 1 or visiting during processing. Your insights may help others make informed, lawful decisions.